everyone, and welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0, and we are on episode 127 Motions in Limine, Witness Proffers, and Sequestration. So, as you can tell by the title, we're going to talk about some witnesses that they might want to call for, some proof of uh, some proof of why they would need to be calling them, why it's relevant, why, bringing it into the case. And that has to do with District Attorney Michael Morrissey and witness advocate Steve Nelson. So we'll read that. There's several motions in limine still that we have to go through. And in this episode, we're going through all of the ones that have to do with, like witnesses, things regarding proffers or sequestering them, and things like that. Limitations on the witnesses. How about that? So please hit that like button and let's begin. So the first motion that I'm going to read is the Commonwealth's motion for offer of proof prior to defendant calling or summoning the Norfolk District Attorney and victim witness advocate as witnesses and request for an order that neither is subject to a sequestration order. So the Commonwealth is apparently not asking for a sequestration order for um, DA Morrissey and Steve Nelson. So they should be able to see the trial and everything that people testify to if they're going to be called as witnesses. That doesn't make any sense. But that is, I think, what they're asking for. All right, so here they're saying now comes the Commonwealth and moves that this court order that the defendant make a satisfactory offer of proof prior to calling and or summoning Norfolk District Attorney Michael W. Morrissey and victim witness advocate Stephen Nelson as witnesses and for a finding that the district attorney and Mr. Nelson are not subject to any order of sequestration. Just an FYI, I know that Steve Nelson was very much involved with some of the McAlbert witnesses and um, preparing them for testimony and things like that. So he would be an important witness. And Michael Morrissey, obviously, Norfolk DA, who is basically railroading an innocent woman. So those two can't remember if Steve Nelson was on the witness list for the defense last year, but I think so. And but they never called him. Obviously, they only called like 4 or 5 witnesses. But so Steve Nelson, and I know for a fact that Michael Morrissey was on the witness list last time, and they had put in some things similar, another filing similar to this as to, show offer of proof before bringing Michael Morrissey, in front of the jury, which I understand, but he made himself a witness with that hostage video that he did where he's like, this has got to stop now. I know that wasn't a great Boston accent. I apologize, but I love your accent and I'm sorry I don't do it justice. All right, so on March 6th, 2025, the defendant listed both the district attorney. So this year they have turned over a potential witness list over to the defense or to the prosecution. The defense has turned over a possible witness list to the prosecution on March 6th. They saw that DA Morrissey and Stephen Nelson were both on the defense witness list. So, when a defendant resorts to the extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to the need for testimony from the prosecutor. Generally, witness, compare in regarding enforcement of subpoena. Generally, witness has a burden of showing why the subpoena should not be enforced. A prosecutor should be called only where there is a showing that the prosecutor's testimony is relevant, material, and not cumulative. Well, somebody did a FOIA request and found out that a Julie, last name redacted, was talking to Michael Morrissey on I don't know if it was a burner account or his work account, but she was definitely talking to Michael Morrissey and I think David Traub, who's the like PR guy for Norfolk County District Attorney's Office. And he retired after Michael Farwell got arrested. If interestingly enough, with the timing there. But anyways, so these emails between Julie, redacted last name, and then Michael Morrissey it's talking about doing this particular video, and he's saying like I'm sending it to all these news media. This is what I'm writing about, and something like I hope it's to your liking. And I can't remember what Julie said in response, but yeah, it's very indicative that there might have been some foul play going on regarding that, and maybe some pressure for him to come out and state on the record that Karen Reed was guilty and others in the house were innocent. All right, so the defendant failed to show that the prosecutor had personal knowledge of relevant factors bearing on officer credibility that could not be elicited by other means. The same principles hold true for the advocate. Victim witness advocate is a member of the prosecution team and notes discoverable or protected by work product rule to the same extent as prosecutor notes. District Attorney Michael Morrissey is the elected official of the Norfolk District, a position that he was first elected to in 2010. As such, he is the elected advocate of the people and the chief law enforcement officer from the Norfolk District. He's so wonderful. Ugh. Sorry. District Attorney is the people's elected advocate for a broad spectrum of societal interests, from ensuring that criminals are punished for wrongdoing to allocating limited resources to maximizing public protection. But I don't see like he's doing any of this, especially ensuring that criminals are punished for wrongdoing when the criminals are the law enforcement officers. They're not enforcing it. They're not punishing the criminals. Mr. Nelson is an employee of the Norfolk District Attorney's Office and is an assigned victim witness advocate in this case and has been assigned to the case since January of 2022. According to the Victims' Bill of Rights, generally requires the staff of the district attorneys to ensure that victims and witnesses are afforded such rights. The victim advocates serve an important and salutary function. They provide victims, witnesses, and family members needed assistance, information, and support, and generally help them to cope with the realities of the criminal justice system and the disruption of personal affairs attending a criminal prosecution during a time of personal trauma. During trial, it is especially important that the advocate engage in an essential function of acting as a liaison between victims and witnesses and the district attorney. That's perfect because if you're doing things illegal or your district attorney is doing things illegal and you're the go between and your DA is either telling you to tell the witness to lie or prep the witness in some kind of inappropriate way, or the DA is doing it and you know about it because you're the victim advocate, you're the victim witness advocate. So you're involved in it, even if you're not the one committing the misconduct, if that makes sense. You're complicit because your knowledge of it. So neither the district attorney nor the advocate were percipient witnesses to the charges before this court. No, but they're percipient witnesses now to conversations between prosecutors and the witnesses. And this case specifically has the issue of, is there corruption going on? Is there a big cover up going on? So for those conversations to not be able to be disclosed might kind of give you some issues, especially, if you're trying to uncover corruption. It makes it especially difficult for the defense when there's so many obstacles against them, and this is just one of them. This is one of the many obstacles is, can you even get Michael Morrissey on the stand? I doubt Bev is even going to allow it, but here we are. I don't know if they're even going to call him, but it's good that he's on the witness list, and I hope that he sweats a little, thinking he might get called at any moment. All right, so neither the district attorney nor the advocate were recipient witnesses to the charges before this court. To the extent the defendant may want to impeach proposed Commonwealth witnesses as to statements, the defendant has not shown the absence of alternate sources of said purported information. Well, I think the fact that these conversations were probably had between Michael Morrissey and a witness or Steve Nelson and a witness, no one else can perhaps verify that or corroborate that information. Another witness might say so, like, no, we didn't talk, or yes, we did, but is that enough? Is that enough? I don't know. So, further to the extent the defendant is seeking either the district attorney's or the advocate's opinions or observations regarding witnesses, mental impressions, research, or evaluation of the evidence of the Norfolk County case, such areas of inquiry reflect privileged work product. So, they're saying all this is work product and you can't have it. Work product rules exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents of the adverse party, which are only the legal research, opinions, theories, or conclusions of the adverse party or its attorney and legal staff. So that's a lot of words saying a whole lot of stuff, but do we actually is it understandable even to an attorney? Like, well, this is my work product. I'm just going to say it is, so you can't have it. Therefore, the Norfolk County District Attorney's Office respectfully requests that this court order that prior to calling or summoning the Norfolk District Attorney and the advocate, the defendant make a satisfactory offer of proof before the court and that the court find that they are not subject to any sequestration. So if you do call Michael Morrissey or Steve Nelson, they should be able to see the whole trial and watch everybody's testimony before you call them. That makes total sense, especially for someone that we don't trust already. But here we are. All right, the next few are motions filed by the defendant. So that was the only one from the Commonwealth. So now we have 4 motions by the defendant. The defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. What do you think this is about? I think about Brian Albert, Jem McCabe, Carrie Roberts, and Colin Albert all sitting in the the gallery, whatever you call it, at trial during closing statements, staring down the jury. Let's see what they have to say. All right, so now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding portions of the defendant's motion in limine to exclude certain witnesses before and after testimony, namely the portion of the motion referencing text messages that are subject to a protective order. So we are going to see. Do we have the motion? No. Yes, we do. Sorry. We have the motion. So we have the motion, but it is redacted in some areas. But we'll get the idea of it. All right. So with this case and Exhibit A containing copy of the text messages. So that's all protected. They want that impounded. Good cause exists for the impoundment of this information because it is subject to a protective order. In support of this request, Ms. Reed hereby In support of this request, Ms. Reed hereby submits 2 copies of the defendant's motion, an unredacted copy of the defendant's motion for the court file, and 2, a copy of the motion with all reference and copies of the text messages that are subject to a protective order redacted. So they're being very careful now because Hank is getting them on any little slip up. If you mention anything that's under a protective order, we're going to come at you in unfiled oral arguments that are completely made up because that's how Hank rolls. All right, so the next filing we're going to read is the affidavit of Elizabeth Little in support of the motion to impound. So I, Elizabeth Little, do hereby depose and state the following is true to the best of my knowledge and belief. I represent Karen Reed, the defendant, regarding the above captioned matter. Good cause exists to file portions of the defendant's motion in limine to exclude certain witnesses before and after testimony, namely all references to text messages obtained from Trooper Proctor's cell phone. So now we know whose text messages who they are talking about, which is subject to a protective order. So Michael Proctor's text messages came over with that whole 3,000-page federal dump, and that was all under protective order, I guess. But things can come out in trial naturally, but or in hearings or whatever, but you can't like reveal too much before trial and outside of a court. So that's why these things are going to be redacted. So here is the redacted version of the defendant's motion in limine to exclude certain witnesses before and after testimony. So now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude certain witnesses from the courtroom before and after their testimony at trial in this matter. Rule 21, which is the sequestration of witnesses of the Massachusetts Rules of Criminal Procedure, states, upon his own motion or the motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. The power of the judge to control the progress and, within the limits of the adversary system, the shape of a trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. Ms. Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, or Colin Albert, as Turtle Boy, the prosecutor in Turtle Boy's case calls him, Colin, Colin Albert, Julie Albert. So Julia, in case you've forgotten, Julie is married to Chris, Nicole is married to Brian, Colin is Julie and Chris's son. Then we have Jennifer McCabe, Matt McCabe, and Brian Higgins from the courtroom. So all of those individuals they want excluded, and I think that's an excellent plan. Let's see what Judge Canoni says. I sure hope that she does, but we'll find out. And here's their reasoning why. So as this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family facing the jury sporadically throughout the remainder of the trial, including closing arguments. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate that the Albert and McCabe families were able to stare down the jury from their position in the courtroom gallery. So I think that word, the stare word, was the juror's actual word because it's in a quote. So it was utterly inappropriate that they stared down the jury. The one juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe families, calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate. Noting that the Albert and McCabe families were substantial focal points of the trial, the juror noted how unbelievable it was that the families were allowed to or were allowed in to stare at the jury, or were allowed to stare at the jury down, I think is what they mean to say. The juror felt it was unbelievable that the families were allowed to stare down the jury, according to Julie Miller, and that is in Karen Reed Tells Her Story Part 2, Vanity Fair. That was out in October. We read through that on my channel. All right. This is, and then we have a whole bunch of redactions, which are text messages, probably from Michael Proctor. This was extraordinarily prejudicial to Ms. Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during closing arguments directly facing the jury, which, according to at least one juror, was intimidating. Reporting that an act need not be overtly threatening to be considering intimidating, and defining the threshold of intimidation as what would instill fear in a reasonable person. We have a footnote here that says courts have recognized that when a witness or person stares down a jury, that can make the jurors feel timid or fearful. Defining intimidation as making timid or fearful, inspire or affect with fear, to put in fear for the purpose of compelling or deterring conduct. Intimidation by the aforementioned witnesses in the context of this case took the form of staring down. That's according to the Commonwealth versus Womack, noting that the jurors' intimidation during a trial where jurors were concerned to leave as there were a lot of people just kind of staring down and making the jurors uncomfortable. As previously noted, an individual does not need to do actual harm in order for an act to be considered intimidation. As the jurors heard through testimony, the Alberts and McCabe families have deep connections and familial ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what she perceived as the Alberts as staring down the jury, which is just what this case law talks about. So, I mean, it's pretty clear-cut case law. I don't know what else there is in this case law that might, that the Commonwealth could argue in their favor, but for purposes of what they've included in this filing, it seems pretty clear-cut that you should sequester these people if they were staring down the jury, and there's interviews of jurors saying that. And not just in Vanity Fair, but the juror in Ronnie, the juror who Turtle Boy had interviewed, also said that he felt intimidated by the jurors. Or, I mean, by the witnesses being there on the last day of closing arguments, staring them down. All right, so here the judge has broad discretion to order the sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses towards the end of trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration order excluding these specific people: Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Ms. Reed. For the above reasons, Ms. Reed respectfully requests that this honorable court exercise its broad discretion to exclude Brian Albert, all those people that I just said, from the courtroom before and after the trial of the testimony at trial. So this they didn't know before. On the first trial, they didn't know that they should have filed this because they didn't know that they were just going to show up at the closing arguments and stare down the jury like they did, like the big bullies that they are. So now they know that that's what probably would happen again if there wasn't a sequestration order. So I'm glad they filed this. I sure don't see a reason why Bev would say no, especially when there's evidence that jurors did feel that way in trial one. So we'll see. Still Bev. Still her courtroom, and she loves to remind everybody she has the discretion. Well within her discretion, she loves to say. All right, so this is the final motion we're going to be reading in this episode. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they have taken the stand. So it was suspected and, rumored there were some witnesses, maybe even multiple. I know at least one, I can't remember who it was, but there might have been multiple witnesses that may have spoken to the attorneys, the prosecutors, when they had already taken an oath and were on the stand, and that is a big no-no. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates, from speaking with or having any contact with any witness once the witness has taken the stand. During Ms. Reed's trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. For example, on cross-examination, Brian Albert indicated that he had spoken with Assistant District Attorney Adam Lawley over the lunch hour while the court was in recess during the middle of his testimony. You're not supposed to do that. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that ADA Lawley had discussed some of the topics he wanted to ask him on redirect. Quote, he maybe mentioned one thing he may ask me. Just he was going to ask about what happened at the house in the morning. Some of the questions on redirect. That's all. As grounds for this motion, Ms. Reed states that the court has discretion to prohibit communication between witnesses and attorneys or third parties. In order to preserve the truth-seeking function at the trial, the court should prohibit agents of the Commonwealth. Like, this should go without saying, but it's so bad and so corrupt there that they have to ask the judge to order the attorneys and other third parties not to speak to witnesses once they've already taken the oath and taken the stand, which is, pretty, it should be common knowledge for a prosecutor that they shouldn't be talking to the witnesses once they've taken an oath. But I guess rules just don't apply there, it seems. So, for similar reasons, the Massachusetts Rules of Criminal Procedure prohibits, or sorry, blah, blah, blah. Let me start that sentence again. For similar reasons, the Massachusetts Rules of Criminal Procedure permits a judge to exclude a witness other than the criminal defendant from the courtroom when they are not testifying. The sequestration of witnesses serves an important function in preventing one witness's testimony from being inadvertently molded by the testimony of others. So you don't want their testimony being shaped by other people's testimony, and it's a good idea, when in doubt, sequester them. All right, so the same danger that a witness's testimony may be molded by conversations with others is present when the witness speaks with the prosecution or other agents of the Commonwealth during breaks in their testimony. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocate, from speaking with or having any contact with any witness once they have taken the stand, and that is signed by all the attorneys. And that is all I have for this episode. We still have more. I mean, we still have many episodes left. Let me pull up my thing here. So next episode will be jury privacy and impanelment. Let me make myself bigger. You guys don't even see my screen here. So jury and privacy and impanelment is going to be the next topic. So things about, the jury asking jury voir dire, things like that. So we're going to go over that. And then next we'll have procedural matters. We'll also go over the Commonwealth's witness list because that just recently came out. Following that, we're going to have a motion that is reconsidering the defense is asking Judge Bev to reconsider her decision on allowing Dr. Crosby in to talk about the medical causation of injuries to John's arm and whether or not they were caused by a dog. And he is actually a dog trainer, not a vet, not a doctor, not someone that should be opining on this. So we're going to go over that. And then following that, Karen Reed. So breaking, it's not so breaking news by the time you're hearing this, but the federal appeal, that her second federal appeal of her double jeopardy was denied by the SJC, but she has the ability to appeal it. They've given her the appealability certificate that is needed for her to appeal. So she has confirmed she's going to appeal it, and it's going to go to I want to say the First Circuit Court. I'm not familiar with the whole, level of courts and how it goes in the federal court system, but that's a good thing, I guess, is that it's getting moved up and um, a more broad federal court is going to look at it, whereas the Massachusetts state court was not, the Massachusetts Supreme Court, I should say, was not going to deal with it. So that's kind of where we're at. So we have several episodes left to catch up, and I'm going to try to get you guys caught up on the motions in limine by this weekend for sure, because on the 18th, we have arguments for the motions in limine with Karen Reed back in court. And I can't wait to hear counter arguments for some of these ridiculous Commonwealth motions in limine and like keeping out the federal investigation, or again redacting, or not redacting, but I guess redacting or impounding the manner of death determination again on the death certificate. So there are all these little things that they're doing, that things that they did last time. So the case is still pretty much the same. You do have some new experts. We'll look at those in an upcoming episode as well. But so that's kind of where we're at. Commonwealth is still pretty much doing the same case. We've got a few more motions to get through, and then we'll be caught up for our motions in limine hearing, which is on Tuesday. I want to say at 9:30, but I can't remember for sure. But definitely I will keep you guys posted for that. So let me know what you guys think. Is Judge Bev going to deny or allow the defense motions? Is she going to just blindly approve Commonwealth motions and blindly deny defense motions? Because I feel like that's how she's been ruling lately, but maybe she'll surprise us and give the defense a few things. She's got to throw 'em some bones, right? To make it look like she's not biased completely or completely corrupt, although I do kind of feel like at this point she's just thrown any kind of disguise out the window of her being impartial, because that's pretty much gone in my eyes. So, what do you guys think? Is Bev completely biased, corrupt? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.